The Insolvency and Bankruptcy Code 2016 is a landmark legislation. It impacts corporate behavior, not just for companies which are going through insolvency, but also generally impacts deal structuring, contract risk management, and corporate behavior overall. At the outset, one of the key considerations in a stressed asset transaction is to understand whether the business or the entity that you are buying is itself under stress or whether it is the seller of that particular business that is under stress. In terms of diligence, it's important to start with identifying the key red flag issues to focus on. In addition to that, given it's a stressed asset transaction, there may be many situations where a proper counterparty indemnity may not be available, and therefore factors such as warranty insurance, price adjustments, and escrow mechanisms need to be considered and weighed in appropriately. Additionally, where the business may be healthy but the promoter of the business may not be in a healthy state financially, the diligence has to be very focused in ensuring that there is no linkage in the context of any securities that may have been created for loans that have been taken by the promoter or any other dependencies on the promoter. It is very important to also engage with the existing lenders at a very early stage and bring them on board with various structural and other aspects. A fraudulent transfer challenge is another significant risk in a stressed asset acquisition. The best way to address a fraudulent transfer based risk is to try and fit within what is called an ordinary course transaction, which is being done on a bona fide basis at fair market value. The IBC also impacts live contracts. Remember, insolvency under the IBC leads to change of management, and therefore there may be an existing contract where you may want to reassess the consequences should the counterparty go through an insolvency process. For example, if you were acting for the lenders to a particular business, and in case there is a major third-party dependency, you may as a lender want to ensure that the relevant third party is not able to walk out of the business the moment you exercise your insolvency-related rights. One thing that the IBC does very well is set out a very clear payment waterfall in case of an insolvency event. Therefore, as a counterparty to a business, you may want to consider whether you can get any kind of security so that you qualify as a secured creditor of the business and therefore are far ahead in the payment waterfall. In addition, there is an opportunity for you potentially to amend those contracts and classify any advances or payments that you may have made to the other party, this property being held in trust for you, so that the IBC waterfall simply does not apply to those scenarios. Many people commit the error of looking at a stressed asset acquisition as an as-is where-is basis transaction. However, keeping all these factors in mind, there is an important need to assess risks overall from a very different perspective. Acquirers and sellers need to come up with robust transaction structures which can see through the light of day. In the context of contract risk management, you need to keep an eye out on the financial health of your key counterparties and therefore start conversations with your key counterparties so that appropriate consequences of stress or insolvency related events are set out in the contracts.